Welcome back. You're watching News Center with me, Ashmit Kumar. Now, the much-awaited data privacy law is now in force. The Digital Personal Data Protection Rules 2025 officially operational. The DPDP Act, with this, the government aims to safeguard user data and hold organizations accountable for how they handle their data and your data, in fact. The rules were notified after a nationwide consultation process that drew nearly 7,000 inputs that shaped the final regulations. Immediately, a 4-member Data Protection Board of India will be formed to enforce data protection laws, and the board will investigate breaches, adjudicate complaints, and impose penalties. The Act also imposes steep financial penalties for non-compliance, up to 250 crore rupees, to protect children. The rules also mandate verifiable consent from parents or guardians for their data. However, that consent isn't required for essential services like healthcare or education or real-time safety. Meanwhile, under these rules, the big tech players get over 18 months to comply. But IT Minister Ashwini Vaishnaw has today said that the government will try to amend them and shorten and compress that timeline. Joining us now to help take us through these DPDP rules and, of course, their implications is with us Aparajita Bharti, founding partner of the Quantum Hub, and Harsh Walia, partner with Khaitan and Company. Thank you so much for joining us. To both our panelists, Ms. Bharti, let me come to you first. As far as the takeaways are concerned, first let's address it from an industry perspective. On the issue of data localization, that is something that industry was watching very carefully. For now, the arrangement appears to be that large big tech companies, while they're processing user data, personal user data, they have the overhang that tomorrow there can be a government committee which can tell them that certain data sets cannot travel overseas. Does that cause some ambiguity, or does that perhaps give clarity that at least we know that there is, as a thumb rule, a provision where I can move user data overseas?
Thanks, Ashmit. And I think this is a very important development that has happened with the DPDP rules. I think the industry is obviously very concerned, especially I think global tech companies, because their workflows and, it causes a lot of operational difficulties for them when there is so much uncertainty about what data localization mandates come in. However, we do need to acknowledge that, this is an indication of the kind of world that we live in and the geopolitics around tech sovereignty, the concerns that we have as a country. So maybe the government wanted to retain this chip with them that can be used for negotiations as they negotiate multiple trade deals. So we do have to look at this in this context. I think a lot of people have also said that this actually goes beyond what is there in the Act itself, because this committee has just been introduced in the rules. So it is possible that some, tech players may also take the government to the court around this, that this is ultra wires of the Act itself. We'll have to see that. But I do think that this leads to some anxiety in global tech companies.
Fair enough. Now, staying with that sentiment of how the industry is responding, Mr. Walia, let me come to you that another one of the aspects that, in fact, some industry members have flagged is a provision of the rules that says that the algorithms that are being used by these companies need to be audited to ensure that no user harm is being caused. How feasible is that going forward? I'm just looking at it from a legal perspective. Will the companies which consider their algorithms to be their proprietary information and data, will they be open to an audit of that algorithm, which again is commercially sensitive to these large companies?
Yes, so I think this requirement of audit was always there under the Act itself. And now the rules have sort of operationalized what was written in the Act. And if you look at it from a harms perspective, yes, if the algorithm is likely to cause any detriment to the rights of the data subjects, that is where the law comes in and requires that that needs to be disclosed. So this definitely is an additional requirement that has been put under the rules. The tech industry and the large companies are definitely going to get jittery about this particular provision. But I think if they qualify as a significant data fiduciary, that is the only time this part will become operative for them. Who will be a significant data fiduciary today is not known. And therefore, I think it is a little bit more time that we will require to understand who is getting caught under this net and who needs to react how. And therefore, I would suggest that it will take still some more time for industry to decipher this particular requirement.
Speaking of aspects that need to be deciphered, Ms. Bharti, let me come to you. AI, of course, has been the buzzword across industries. What I want to get to you is that at a time when India has its own AI aspirations, India is hosting the AI Summit in February of next year, 2026. How does this rules, the way they are configured as of right now, along with the Act, what does that mean for training of AI models? I just want to get a sense. Is there, will they be considered as an exemption where they're doing research and therefore they are exempt? Or will they also need to fall in line with the broader DPDP Act and the rules?
Ashmit, very good question. I think, to be honest, in short, there is no clear answer in the rules. The Act basically does give an exemption to all publicly available data that has been made public by the data fiduciaries themselves. But it is very hard for any training model to understand what has been made public by the data principals themselves. Right? Sorry, I meant data principals. If they make their data public, then that can be used. Also, there are exemptions for the limited purpose of research. However, if AI models are being made available commercially, that would not qualify as research. See, the Act was passed in August 2023. We had the chat GPT moment in November 2022. So to be fair, this act was very much already in very, later stages of when this was getting finalized, when Gen AI came to the scene. So we have not been able to address this fully. And it's possible that the government may have to amend the act to make some sort of scope for AI training to happen, as it is also happening in EU. They are also looking at GDPR from this lens now because this is a new tech, and maybe new provisions need to be introduced in data protection laws to make room for this.
So may need further tweaks, but that's an important bit of clarity coming in, Ms. Bharti, that as far as India is awaiting its own chat GPT moment, is looking for its own LLM, and in trying to do so, are AI models, especially for commercial use, exempt? That's one question that needs perhaps further clarity. We're running out of time, Mr. Walia. Let me come to you. As far as some of the social issues are concerned that have been flagged, one issue that repeatedly kept coming up is that most data protection regimes have protection and exemption for journalists. India appears to be the only exception. Is there any protection available to journalists that you can see as a part of the rules or as a part of the Act, or are they liable now to face action under the DPDP?
Yes, that's a very interesting question because it was debated long hours that journalism is a part of exemption under the GDPR as well, and it should somewhere figure in the DPDP Act or rules. Unfortunately, it is not there. A couple of indications here are that one, it has to be seen how the legislation is implemented, and if it is causing real challenges for journalists and media houses. Secondly, they are treated as good or as bad as any other data fiduciary. Therefore, everything applies to them as it is. Right to erasure, right to correction, all of that will apply as of now. This is the law. And I think what we have to ultimately look at is the constitutional provisions under Article 19. And some interpretation will get into checking if journalism can be an exemption or can be used as can be utilized where there is not an issue as far as journalism is concerned. On top of that, there is one
Fair
fine
enough.
exemption in the legislation which says that there could be further exemption by the government.
Right.
Those exemptions are available to the government till 5 years to give to certain additional data fiduciaries. Journalism
So the
can
focus
fit into
again
that.
shifts back to the government on this one question, that whether or not journalists are exempt. We pose that question to the government officials. What they're telling us is that there's a list of FAQs that are expected, and that perhaps will give clarity on the way forward. We're running out of time. A final question, Ms. Bharti, let me come to you. Another aspect that has drawn the attention of a lot of analysts has been Rule 23, which basically gives sweeping powers to the government. The government can call for any data from any intermediary, from any company, if it is for national security purposes. How are you responding to this power that the government has blessed itself with?
Ashmit, I think, all governments retain some of these powers when it comes to national security. I think there is a seventh schedule as well, which basically, lays out some criteria for which this rules, this information can be sought for. I think the industry is concerned, but as you know, jurisprudence also develops around this once the DPP is operational. I think we will have some safeguards that will also come through some of this jurisprudence. So I think there are some concerns, but obviously government also needs some of these for national security issues, and I think most governments have certain enabling provisions for them to get information out in when it comes to security issues.
Final 10 seconds. Do you see that these rules will have their day in the court as well, Ms. Bharti?
Absolutely, Ashmit. I think everybody has so many issues.
Well,
I mean, the FAQs will definitely help. I think as the industry starts complying, we also have to understand that this is a horizontal legislation. So it applies. We are only thinking
right.
about big tech right now, but it applies to all
Right.
medium and small businesses as well. So
Right,
definitely,
Ms. Bharti. I'm afraid I'll have to interject there. We're completely out of time. I'd like to thank both of our panelists, Ms. Bharti, Mr. Walia. Thank you so much for being a part of this. With that, it's a wrap on this edition of News Center. More news and updates will continue on the other side.